Hewitt, the Executive Director of the BLAC Legal Action Center. I'm excited to be a part of this event after 4 years of toil and work and challenges. It appears that we are coming to, well, the end of one phase and the start of another. The launch of the BLAC Justice Hub, a lot of familiar faces in the room, and I do see some familiar faces online. But before we get going, we want to follow the usual protocols with doing our land acknowledgement. So for that, Owen.
Yeah.
I'm a summer administrative assistant here with BLAC Legal Action Center. And thank you for joining us today for the event that we have of the launch of the BLAC Justice Hub, and those of you online and also in person. And to begin today's event, I would like to acknowledge the land on which we are gathered. BLAC Legal Action Center recognizes that our work takes place on traditional indigenous territories across the territory now called Ontario. We acknowledge that there are 46 treaties and other agreements that cover the province. BLAC also acknowledges that our head office is located on the land known as Toronto. It is unceded and ancestral territories of the Anishinaabe, the Chippewa, the Haudenosaunee Confederacy, the Mississaugas of the Credit River, the Wendat, and many diverse First Nations, Inuit, and Métis people. It is covered by Treaty 13 with the Mississaugas of the Credit and the William Treaty signed with multiple Mississaugas and Chippewa. To peacefully share and care for the lands around the Great Lakes, BLAC also acknowledges the many people of African descent who are not settlers, but whose ancestors were forcibly displaced as part of the transatlantic slave trade brought against their will and made to work on these lands. We believe that advancing indigenous sovereignty is deeply and inextricably linked to BLAC liberation, and we will continue to mobilize and take action in solidarity with indigenous people and communities. Thank you for attending the event.
Thank you, Owen. All right, so the BLAC Justice Hub, in case for those of us wondering what it is. Oh, they can't hear us online?
Yes, I know.
So
the BLAC Justice Hub is what we call the end product of a project that was started by the BLAC Legal Action Center in 2022. So we're 4 years in. And I confess, it has crossed many different leaderships of that. I'll give the rest to that. But I'm still happy that we are here today. Just a few months beyond the launch date back in 2022. Actually, a few months ahead of the launch date back in 2022. So we're just about touching the 4-year mark. And the Department of Justice, as the federal justice center, entrusted us to develop resources for legal professionals, social justice advocates who are involved in the work that we do. So at the BLAC Legal Action Center, we have a community legal clinic focused on combating systemic and individual anti-BLAC racism. As a legal aid clinic, we provide services to low or no income Ontarians who have experienced anti-BLAC racism. So the bulk of our work that we do is focused on providing representations. So the project envisioned the creation of legal resources in 5 main areas of law, and that's where we're starting today, and certainly build out it as we go along. So the 5 main areas of law that we were interested in develop those resources, criminal, and I should say, these are areas of law where we recognize, or it has been recognized, that when BLAC people come in contact with the justice system, they may be disproportionately affected. Criminal law, the main culprit, nobody needs to argue about that. The stats are there, and the bulk of the material we have is really in criminal law, because that's where the challenge is when BLAC people do get in interact with the criminal justice system. We do have prison law materials, civil litigation, child protection proceedings is still one of those areas when BLAC families come in contact with. So when BLAC families come in contact with Judicature society, certainly once you're in that system, once CAS gets involved, certainly it's downhill from there. And it's really hard to drag yourself out of it once you have a CAS file. It's probably just as bad as when you get into contact with the criminal justice system. So child protection. Immigration is one of those areas, of course, where we do have, Black people being either systemically disadvantaged going through that immigration system or being barred altogether from, different resources or different streams within the criminal justice system. Have I gone 5? I don't know if I have, but child protection, civil litigation is the one I haven't done. I see Atrisha, she reminds me of civil litigation because she's the lead on that one. So civil litigation, how it is that you raise and argue anti-Black racism in civil proceedings. So the idea behind the project is that we're developing these materials, and the discussion we're having today is to highlight how it is that over the past year, the materials we've developed, the materials we've tested, how it is that we raise these arguments, how it is that you recognize where anti-Black racism might actually be an issue in the proceedings, how it is you raise the arguments and bring it to the courts, to the court's attention. There are different ways of doing it based on where you are. So certainly when we think of anti-Black racism, race issues, we automatically default to proceedings in the Human Rights Tribunal. But of course, we do recognize that there are many other tribunals in which you can raise issues of anti-Black racism. We are now in that area where race, DEI, and all those things are topical issues. Certainly, we are in that phase where, a few years ago, you would be canceled for saying something anti-DEI. But certainly in today's age, you may actually be promoted or spotlight or platformed for saying things anti-DEI. So we're in a totally different climate. And I will admit, most of these materials were developed when cancel culture was a little bit stronger. So we probably have to keep that in mind. But, one of the good things that we do recognize here in Canada, that we do have a court system that's quite robust, quite in tune, and judges and advocates and tribunal members who have not gone as radical as we have seen in other places and are certainly willing to enforce or charter rights and all the protection that we enjoy as Black people. So that's the discussion we're having today. We will be walking through a few of the materials that are on the website. I want to flag, though, that the website, even though it's been launched by us and managed by the Black Legal Action Center, it is the community's website. The idea behind the Black Justice Hub is we are woefully short on the statistics. We're woefully short on where we go to find material to advance our arguments and cases, the research here in Canada. Certainly, if you can think of a topic and you do a research, you might be able to find material down south and in other places on Black issues. We don't have that here in Canada. And so the idea behind launching this phase is that we now have a centralized place where it is that we will host the material. I say it is the community's website because we are entrusting that you would also contribute material to the website. Certainly share them with us that you think are quite important, things that are happening in the community, whether it is a research that you've concluded or conducted, whether it's material that's already out there but we haven't come across it. Certainly we are a community clinic, a very small one. So we will miss a lot of the work that you're doing. So please share those with us. But we want to have that centralized space where we now can go to find these materials and make it a little bit easier for us when it is that we're making those arguments. Even at Black, we struggle to find some of these statistics when we're arguing these cases. So I would love to feel them. We will post our on the website. You will see your email and send them to us. So we'll go through and we'll upload them as we go along. So today's the launch. There are materials there. We're still uploading materials to it. So you might be missing a few things. But hopefully, as we go on, you'll start to see the practical benefit of the materials that are there. All right. So our moderator for today is our community legal worker. Dr. Sanjay Campbell will walk us through the presentations today and introduce our speakers. And then we head on. In the end, we're having a little chat about how it is that your views on the website and how it is that we can further develop the website. All right. So Sanjay, over to you.
Thank you, Demar. So like Demar said, the Black Justice Hub was developed through the contributions of legal professionals who have extensive have extensive experience supporting individuals navigating complex legal systems. So to begin our discussion, we have invited several contributors to share their perspective on access to justice as well as the development of the hub. So our first presenters are Tafiq Hasmani and Melody Izadi. So they both are experienced criminal defense lawyers. All right, so we're gonna switch it a bit because Melody is not here. So is it okay if we move to Atricia? You're fine? Okay, all right. Right, so our first presenter is gonna be Atricia Lewis, who will discuss civil litigation, access to justice, as well as development of the practical resources for community members. Thank you.
Okay, hello. Can you hear me? Okay, great. So it was my pleasure to contribute to this Justice Hub in the areas of civil litigation. And I'm going to explain a little bit about my background because I think it's relevant to how I see things. So I have my own civil litigation firm now, but before then I was a partner at a large national firm for a number of years, and I practiced at this large national firm for a large number of years. And so I say that because I was mostly defense counsel in that context, and in civil disputes. And I think that really informed how I think about cases, because I often felt like there were missed opportunities for many plaintiffs in pleading cases, advancing cases. And I always just felt like, if I was a plaintiff, I would do this, this, and this. And so I bring that thinking with me now as a plaintiff's lawyer. And there's three key takeaways I would like for people to think about when they're thinking about civil litigation, okay? And I'll get into that in a second. So the goal of the civil litigation materials are really for people to start thinking about advancing anti-Black racism and discrimination claims in the context of civil litigation. And my experience generally, and this is the first takeaway I would say, is in this current climate, I think if you can get out of the Human Rights Tribunal, you should try to get out of the Human Rights Tribunal. And the reason I say that is because my experience with the Human Rights Tribunal is it's very slow. It takes a really long time to get anywhere. And so the delay is a big one. And I think they are less friendly to some of the discrimination claims, to be candid. So how do you get a case out of the Human Rights Tribunal? Well, unfortunately, the Human Rights Tribunal is the court, or not the court, but the tribunal of jurisdiction for discrimination cases in the context of services and other relationships, including employment relationships. It has exclusive jurisdiction, but there is a carve out, and that is if you have another cause of action. And so if you have another cause of action, you can get out of the Human Rights Tribunal and you can advance a Human Rights Code complaint in the civil action. And that's often what I encourage people to do. Sometimes I'm stuck in the Human Rights Tribunal because I cannot find a way out, but if I can, I try to get out of the Human Rights Tribunal. And so one of the key takeaways I want from everybody is in civil cases to think about pleading Human Rights Code damages. That's the first. And so I think of it as trying to get out of the Human Rights Code, or out of the Human Rights Tribunal. But I also think a big missed opportunity in a lot of cases are you have cases that are relating to other issues, but there is clear anti-Black racism, clear discrimination, but it's not being raised. Human Rights Code damages are not being sought, and a Human Rights Code claim is not being advanced. So some examples that I see often are in the medical malpractice case. So you'll see a lot of cases about delayed service, delayed diagnosis, improper treatment, compromised baby, all sorts of medical negligence claims. And people advance those claims. But then I observe, now I say I observe this as defense counsel in a lot of med mal cases, is most of the plaintiffs are racialized and many disproportionately and compared to its population are Black in Ontario. And I think about what is animating the delay in diagnosis? What is animating some of these healthcare challenges that are facing this population? And I think it's a missed opportunity when plaintiffs don't plead breaches of the Human Rights Code. to advance their medical negligence claim. So that's one example, but there are many other types of examples where if you peel back and ask your client and talk about what's happening, you'll see that there is a human rights dimension to this, and I would encourage you to advance that claim. There's a provision in the Human Rights Act that lets you advance a human rights code claim in the context of a civil action, and I would encourage you to use that. So that's my first takeaway, is thinking about advancing human rights code claims. The second key takeaway is similar, and that's in raising Section 15. So Section 15 of the Charter, discrimination claims. That's limited, of course, to governmental action and government actors. But I think it's also sometimes a missed opportunity that people don't advance these claims. And I'll give you a couple of examples. So one example is, and you may have all seen these class actions relating to solitary confinement. And there's a lot of claims being advanced about Section 7 of the Charter and how that's being violated. But I also think if you paused and you thought about who is being disproportionately segregated, it is Black people and it is Indigenous people. And so I thought it was a missed opportunity that many of those class actions that led to big amounts of money for each individuals didn't include advancing those kinds of claims. And so my second plea, frankly, to everyone who's doing civil litigation and then charter litigation is don't forget the Section 15 claim. It's important to think about, and I think it can be advanced. The third thing I would say in civil litigation is to think about claims such as racial profiling. And I'll give you an example of a case that I did where I think racial profiling was really important. And I don't think it was clearly articulated necessarily until I got involved. I have a bias, as you can see. And the issue was my client was arrested by security guards at a store. And in that arrest, he was injured. So he brought a personal injury claim. The store justified the arrest on the basis that it wasn't with the police, it was a civil arrest, on the basis that there was a trespass to property act that permits the arrest. So if you are asked to leave and you don't leave, you're trespassing and you can be arrested. That was the argument that the store advanced in this case. And the counter argument I had to that was you can't invoke things like the Trespass to Property Act if you're doing so in a way that it amounts to racial profiling. And so in this case, which is actually it's going to appeal right now. I think it's a really interesting case. But in this case, the argument that we had, I thought we had pretty good evidence of racial profiling because the guard who arrested my client and injured him wrote in his note that my client had an extreme history of violence and multiple dealings with the police. And guess what? My client had no criminal history, and the guard couldn't remember where he got that information from. It was totally false. It was made up. And to me, that is very clear evidence of racial profiling. So thinking about how you can advance racial profiling claims, not just as a sword, but as the shield to defenses that may be raised in civil cases. So that's the third takeaway. And then the last thing I want to talk about is thinking about other tools for change. And this is something that I'm quite excited, and it's not part of the hub, but I think it's just important to talk about, is a partnership that my firm is doing with BLAC on behalf of refugees and refugee claimants who sought shelter beds in the city of Toronto and who were denied a shelter bed. And so there's a proposed class action that's being brought right now. Certification will be heard in April next year because justice moves slow. But I think it's an important example of the benefits of scale and the benefits of tools like a class action. And I say that for a couple of reasons. So one is if for each individual who's denied a refuge, each individual refugee who's denied a shelter bed, and the reason they were denied the shelter bed was because the city of Toronto at the time had a practice of saying, if you're a refugee or refugee claimant, you don't get the shelter bed. The shelter bed's for non-refugees. And let me tell you, you can't do that under the Human Rights Code in our charter. But the benefit of a class action is each one of those cases is probably not worth a lot of money. It's not, the city won't feel pain in response to an individual claim. It doesn't have the benefit of creating systemic wide changes. And even as an individual litigant, I'll say as counsel, like I'm always thinking about how are we going to fund these cases? And when I think about a class action, then a lot of funding options open up. So this class action is being funded by the Class Proceedings Fund, and that lets us retain experts to speak about the unique circumstances of refugee claimants who during this period of time were mostly from African countries, and speak to we're able to hire a statistician. We're able to lead the evidence that we need to lead to prove these cases, which you cannot do on an individual scale. And so that's the other tool I would invite people to think about, is the tool of class action. And BLAC has been a great partner in advancing those, both on the refugee bed class action and then one on carding, which has been recently certified against the Toronto Police Services for their practice of stopping and collecting data disproportionately impacting the Black and Indigenous communities in Toronto. So all of that is to say, I think Damar, when he spoke initially about how we think about anti-Black racism, we often think about Human Rights Code, we often think about the Human Rights Tribunal. And my big invitation and plea is to think about civil litigation, thinking about advancing those very human rights challenges, but in courts, thinking about pleading Human Rights Code challenge damages in a case that you may not on its face think is about a human rights issue, because you may be surprised that there's often an element to it. Thinking about sections 15 when you're advancing charter claims, I think is also important. And then thinking about how you can use concepts that exist in law, such as our law on racial profiling, which is actually great. There's great law in that area when confronted in civil cases, not only as a sword, but as a shield. So thank you.
Thank you, Tricia. That's a powerful reminder that race can be a relevant factor even when the case appears to be at first glance about something else. So our next speaker is Antonia Johnson, an immigration law practitioner. So his work focuses on immigration as well as refugee matters. So Antonia has contributed to the development of the hubs in terms of the immigration law resources, and will share reflections on access to justice for newcomers as well as migrants navigating legal systems.
Good morning, everyone. Thank you so much for joining me today. My name is Antonia Johnson. I'll be doing a brief presentation on Black history. I do have a presentation and just like Damar, I do speak very quickly and fast, so my apologies about ahead of schedule. So if I can have the first slide, please. I think that's it. Okay, so we already have that. Okay, next slide, please. So today I'm going to do a brief introduction of who I am and what I do. So today I'll do a brief introduction of who I am and what I do. And then I'll go into some of the core discussions that I have, which is divided into 4 different parts. There's the structural barriers that Black people face, and the big thing is the credibility aspect of it. Part 2, we deal with the power of accessible legal information, where knowledge is power. Section 3, we will talk about leveraging how Black Justice Hub for Black is important to Black people. And there's a key takeaway that I want everybody in this room to take from this. And then I'll end with a brief conclusion. Next slide, please. Like I said, my name is Antonio Johnson. I'm an independent immigration law practitioner practicing within the GTA region. My work reflects a strong commitment for justice, access to justice, protecting human rights, and particularly for immigrants and non-immigrants, and racialized communities within the Canadian immigration regime. I do hold a Bachelor of Arts with several other certificates, including tribunals, courts, in addition to a Master's of Law in 2026 in Administration Law. Okay, next slide, please. So the first topic I want to talk about is part one, which is about the structural barriers and the credibility tax, and that's very important. It's an important thing I want to take away from this today. Next slide, please. So the reality of the situation is a navigation factor, right? So racialized individuals and Black immigrants, they are faced with the dysphoria of challenges. They do not navigate the system because it's racist. It's not a neutral bureaucracy, and it's unfortunate thing for Black individuals in the reality of the situation, in that they encounter these things in the immigration system regime because it's built on entrenched racist, overt or sometimes an covert aspect, especially when it comes under the credibility aspect of it. And that's something I want to take away. I want you guys to have a pinpoint on that because I'll go deeper into that. So for those of you who do not know what the credibility aspect is, the credibility aspect is the extra burden that Black individuals has to face when they go in front of the immigration regime, right? So they have to explain things better. They have to bring additional documents. Their word is not good enough compared to their other counterparts. And that has been plaguing our Black community for years, and is very rampant immigration system. And unfortunately, there's an aspect of the Immigration Protection Act where it says credibility rests with the officers, the administration officers. They are the ones who have to prove things to. And that's reflected in section 106, 107, and 170 to 73 of the Immigration Protection Act, which is something we cannot really fight actively on our own. Next slide, please. So that leads us into the second thing of overlapping systemic barriers. So there is a convergence of anti-Black racism, which is very precarious in the immigration system regime, as I mentioned. So I just talked about the administration officers, and they frequently penalize Black individuals in everything that they do, whether it's going to be a cultural communication aspect of things or the most important source of country origins. So they harbor Black stereotypes, and they look at negativity that was once said in the past, and they do utilize this information to make their decisions, which is unfortunate for individuals, and it does affect their credibility. I can recall doing cases for a client who apparently he's from Africa, and I went there to get some information for the client, and he has an expired passport. And the information was given to me at the CBSA, and then we had some challenges where I had to get the actual passport because it was expired, so I can renew it in Africa. And all of a sudden, because they knew what I was trying to do to keep the client here, magically, the client's passport, birth certificate, and all supporting documents disappeared. And it was no longer in CBS realm, and I was told, oh, we misplaced the file. The question is, how can a large entity or organization like CBSA misplace files that's that important to a client? The issue is, it took me another year and a half to secure those same individual documents to assist the client. And the issue was, they were trying to get the client out faster. Not having this information, these documents, means they can easily export the client. So this is one of the things I want to make sure you guys are aware of. Next slide, please. Then this is why there's an access to immigration justice gap, right? Where it boils down to legal fees. When you encounter issues like this, not all applicants and refugees, there's a socioeconomic issue where they cannot afford certain things. They cannot afford the right counsel, or counsels really learned or acknowledge the issues that they're having. So it's difficult for them to choose. And so it's a predatory thing where individuals have to pay a lot of money they don't have. They are already disenfranchised from not having the job that they were trained in, having coming from a different country, or having mediocre jobs. So that's an issue for them. So they hire unregulated individuals, or individuals who have no idea what it is that they're doing, which affects the deadline, important deadline nonetheless, for example, meeting a certain criteria for the refugee board, or even taking a matter to the federal court. And these are high-stake individuals or high-stake representation. And of course, that also leads to individuals being self-represented. Now, if you're in certain aspects of immigration, it's not recommended, it's highly recommended not to proceed without legal counsel. Next slide, please. So part 2 deals with the power of accessible legal information. Okay. And there's empowerment through legal literacy. So having accessible legal information is important because it prevents measures of administration functions. It reduces the likelihood of disenfranchised individuals or individuals that are racialized for them to have some form of knowledge, having read something before, and to understand that there are deadlines, and in additional, not to foster or procure or bring forth documents that they think, right, or immigration think they can use against the client. Now, a side tip to understand too as well, whenever, in the immigration realm, that is, whenever any individual bring a case in front of immigration board or immigration cell IRCC, the case is not for you to prove. It's for them to utilize every single drop of evidence against you. So in my perspective, individuals get approved not because they've done what needs to be done, is because they cannot offset whatever evidence was brought forward. So it's up to us. If you bring something positive, they will look at the negative aspects of it and they will criticize it. And I see this especially for Black individuals. So having some form of empowerment and literacy is important for us. Next slide, please. Then if you have education literacy, then it prevents irreparable errors, right? It's kind of like going to the hospital and you got to get triage after what's happening with the nurse. Which doctors see first, what's important, what symptoms you having. It's the same idea when it comes on to immigration. So having this, it prevents individuals from signing predatory agreements where you're locked into a contract with somebody who's not able to represent you properly, right? There's strict federal deadlines that we discussed also. And then the non-legal compliant paperwork that triggers deportation. This is a nightmare of immigration because if you work on a case for a client and certain documentation are not reviewed properly or submitted by accident, or it looks shaky. And shaky means not everybody is a first world country like Canada. So our documentation does not always look the same. And if it doesn't, then immigration will kind of question it. Why is this? What is this happening? Believe it or not, some of these documents are written, handwritten still. Birth certificates, baptismal certificates, marriage certificates, and it questions the things on the credibility claims, which I just said initially. And of course, these can trigger deportation risk if you're not submitting the documents properly. You see that as a part of misrepresentation in Section 40 of the Immigration and Refugee Protection Act. And of course, the most famous is the Section 44 of the rules, and that triggers inadmissibility, which is something Black people are always being encountered to. For the smallest issues, it's always about deportation. Other issues, other races, cultures, they get to stay, but Black people always get to go. There's a racial aspect of it because individuals are scared. They're the one who get encountered in the street or having a haircut, and they get nabbed by the cops, and they get searched for CBSA warrant, and then all of a sudden, you're in an immigration lockup, and this all comes into play because of Section 44. Next, please. So that leads to fostering legal advocacy or legal agency. So having a complete understanding of the administration mechanisms and how this mitigates the acute isolation of psychological distress. Yes, Black people do have a lot of psychological distress because there's systemic racism. We have to fight above and beyond what our normal counterparts do just to survive in this country. And these disenfranchised groups need to be empowered so they can have this knowledge and use it forward. Not to say, okay, the state has said you need to submit this, this, and this, but having some idea of what's going on and where it should go, right? That's going to empower individuals in their own legal defense. And remember, when it comes down to this, knowledge is power. The more knowledge you have and the basic information you have about immigration, the more you can actively speak about your claim, speak to an individual who's representing you to make sure they do understand what is it you're trying to do and how your claim is going to be successfully resolved. The next one, please. And that leads to leveraging the Black Justice Hub. So from a culturally competent perspective, the Black Justice Hub Immigration Resources offer essential interventions and utilizing Afrocentric perspective, trauma-informed methodologies, and of course, to address the systemic anxiety, what you just mentioned, experienced by racialized groups. And we need that to dismantle the barriers and institutional trust, which is still a work in process. Because Black individuals do not trust the immigration system, and I cannot blame them. I've seen it. As a Black individual who's learned, I've gone to immigration, I've seen several issues where they have with me as a counsel, imagining what they would do if it was with a client. I recently recall a situation where an individual called me and contacted me saying, "You have the client, I would like to speak to him." And my response is, "Thank you, but you speak to me, I'm counsel." And of course, I'm assuming because of my culture, my race, because I know what kind of individual it is, no, we want to see the client only. Well, any sane individual who works in an organization, which is an issue to begin with, you need to speak to counsel before you can talk to the client. So of course, I went in to find out what was happening with my client. They were not happy. They started saying a lot of lies. The individual has criminal records. The individual was supposed to show up and he didn't. None of the information is correct, and I'm getting a lot of different perspective of what this individual is saying. Which comes to shove, long story short, is I had to end up filing a report with the ombudsman of the immigration because everything that came out of the officer's mouth was just fabrication. In the end, it was found that I was the one telling the truth and not the officer. And it boils down to the fact that, Antonio, what is it that you want done? What do you want with this individual? Now, having understanding that there's unions involved and there's all sorts of issues involved, I said, I just want you guys to be aware that you do have systematic racism in your organization. This individual did not know me or my client, but at the same time, you went ahead and misjudged them, and then you fabricated information just to make yourself look good. And the excuse they gave is, this guy is seasoned, he's been in the industry for 25 years or 30 years, he doesn't understand. Well, he needs to be out of the system because having that kind of thought process is not a requirement in immigration Canada, and it's definitely a requirement in our society today. Next slide, please. So optimizing frontline is still part of the triage system. Well, you have the resources that extend well beyond equipping frontline workers, the people in the grassroots section of it, to advocate on our behalf and to deliver immediate responses for all disenfranchised and racialized groups, especially Black people. Next slide, please. So it also enhances legal practice. So it's an evidentiary document. What we do, we contextualize what's happening in the conditions, and we use this to uniquely balance the Black diaspora and utilize these tools. Like I said, if you come to these hubs, you get some form of indication and information that you can use and disseminate to your individuals, your people, your cases, whatever the case may be, to assist you in fighting anti-Black racism. Okay. And the last thing I want to talk about is the key takeaway with section 4. Right? So instead of raising something, I want to propose this question to you saying, how can we as Black legal professionals, advocates, and allies actively dismantle the credibility tax I just spoke about within our own daily immigration case, intake, and representation? Whatever your thought process is, it has to center on the fact that we need concrete explanation. We need to be very rigorous and objective in presenting our evidence. And we have to use binding jurisprudence. There's case laws. There is the Baker well-known case where best interest of the child. There is actually Kentesami, a refugee, was displaced and got deported and tortured, and Canada knew it was going to be tortured, and he ended up going away but coming back. There's other aspects. There is Vavilov, and of course, there is also procedural fairness. Any breach of procedural fairness is an issue. It's illegal. We have, as advocates, have to look into everything, comb through your clients' cases, ask them specific questions. Not everybody is going to come out and tell you exactly what's on their mind. You, as advocates and allies, have to look at the client and start asking and probing, and they will open up. And you utilize all that information, and you utilize it, and you make a claim for the client. I'm working a case right now with an individual, and that person, I thought I had a good rapport with the individual, but when it comes on to immigration rejecting the case, I'm thinking, okay, how else can I help this individual? And I started talking to them. And then I started realizing there's country conditions, there's issues that's been going back home. The client was actually lacerated with a knife by gangs. And all this information came up because I spoke to the client. I often thought I had a good rapport. So I'm using this as best practices to say, I have been doing this, and it does that. This, in addition to everything we discussed, is what's going to offset the credibility tax. You say what you're going to do what you're going to say, and present the evidence. It's impossible for you to say a client is going through A and you don't have evidence to submit, right? You can send the client to a doctor, get a doctor's note. I just did a psych evaluation for the same client I'm discussing, and it opened a whole slew of issues that was going on with the client, which is evidentially evidence, which I can use now to offset everything that immigration has to say. So our case became a lot stronger. And the last thing I want to leave you with is a conclusion to think about that. In Canadian immigration and administration law, systemic forms of bias, including credibility tax we discussed, and the manifestation of anti-Black racism are likely to be overcome through emotional appeals themselves. Instead, I will encourage and recommend that legal practitioners to strategically engage with the legal system by weaponizing its own substantive and procedural framework to challenge and hold accountable the structures through which these biases were initially created and have been reproduced continuously in our society. So that's all I want to say for that today. Thank you. Have a nice day.
Thank you, Antonio. What I'm hearing is empowerment. When people understand their rights and the system around them, they are better equipped to advocate for themselves and their communities. All right, so we're going to shift things around a bit. We're going to take a short break right now, so 5 minutes. So we do have refreshments. You can help us have the refreshments at the back, and we will reconvene shortly. So 5 minutes break. I will now invite our chair of board, Nani Mwambote, to come and introduce our special guest.
Good morning. And I just want to, can anyone hear me? Raise your hand because it seems like everyone distracted. Okay, thank you. Good morning. My name is Neto Naniwambote. I'm honored to serve as the chair of BLAC Legal Action Center. And I want to thank everyone who comes here, and I want to thank everyone who comes here for this launch. And I wanted to extend our deepest gratitude to the Justice Department for funding this project. I just want to highlight some of the projects that we're doing in our clinic. This summer, we are once again partnering with Law Action within school to support high school students facing barrier in post-secondary education to workshop, mentorship, exposure to legal career. These young people are gaining meaningful insight into the justice system and opportunity within the legal profession. We also continue our Black Future Justice program, which introduces young people to legal career, help foster and generation of lawyers, advocates, and community leaders. To Canada Summer Job Program, BLAC currently hosting students who are gaining hands-on experience in the community engagement, legal education, research, advocacy, and building practice skills while contribute directly to our missions. Early this year, we successfully delivered empowerment Black youth with the unique ability, which support Black youth with disability to employment readiness and training, mentorship, and skill development, and reflecting the commitment building exclusive partner to empower community participation. As soon as we launched the Black Legal Circuit Care, the trauma-informed initiative developed in partner with the organization support Black individual families who impacted by gun violence, hate crime, and other forms of victimization, because we believe the access to justice must also mean healing and support our community. For all this work lead us to us today is the Black Justice App, which provides practical, accessible legal information to system navigation, source of Black community advocate, legal professional, and service provider across Canada. It's a reflection of Black enduring commitment to address anti-Black racism in building more just, equitable legal system to everyone. None of it would be possible without the Justice Department. We're deeply grateful and support. It's now a great pleasure to introduce our next guest, the Honorable Sean Fraser, was appointed the Minister of Justice Attorney General of Canada in May 2025. As a minister, he is responsible for overseeing the federal justice system, advancing legal and policy reform and supporting initiatives that promote access to justice across Canada. Please join us to welcome the Honorable Mr. Sean Fraser, who's online with us. Thank you, Minister.
Thank you so much, Neto. Before I get too far, can you hear me okay in the room? Yeah, okay, I'm getting a thumbs up, so I'll begin. Look, I want to thank Neto and everyone for at the Black Legal Action Center for inviting me to join you virtually to today's event. The launch of the Black Justice Hub. This is an important milestone. It's one that I think deserves celebrating, and it's going to have a profound impact when it comes to increasing access to justice for Black Canadians and particularly those who are going to be served directly by the hub. This is something that represents the culmination of a commitment and hard work of a lot of people over many years, going back to at least 2018 with the needs assessment on certain key legal issues that were affecting low-income members in particular of Ontario's Black communities, as well as Legal Aid Ontario's racialized community strategy. It's pretty obvious from this work that legal professionals needed better access to information to raise some of the best legal arguments that are going to address head-on anti-Black racism in the justice system in Ontario and in Canada. This is where the Black Justice Hub comes in. Justice Canada has been supportive, obviously, of the work that you're doing with $1 million contributed back in 2022, which came from the Justice Partnership and Innovation Program. But before I get too specific into what it's going to do, I hope to reflect a little bit on the importance of the work that you're doing. It's pretty clear when you take a look at the justice system that there is enormous room for improvement. Over the course of my time in this position and over the course of my life, I've come to understand the differential treatment doles out to communities from different backgrounds, from different walks of life. There's a number of different ways in which these inequities manifest. Obviously, you can see it in overrepresentation amongst incarcerated populations in Canada. You see it in the overrepresentation when it comes to people who are the victims of crime. You see challenges in certain communities that are over-policed and challenges in communities that don't have access to the policing services that they need. Access to services is a broader challenge that I witnessed, though not necessarily in the justice system specifically, but it still touches on the ordinary meaning of justice in my own mind. It's not right, in my view, that there's inequity in access to health services or infrastructure, for example, when you look at communities that are disproportionately made up of Black Canadians. We see a lack of representation in positions of authority across Canada, both in corporate Canada and in governance. And that manifests itself in a lot of very challenging ways. For those of you who I've not had the opportunity to meet before, I come from Nova Scotia and see dramatic differences in the representation of the African Nova Scotian community when it comes to positions of authority, and policy decisions that have been taken over time have a differential impact. It's not a coincidence in my mind that we see waste treatment facilities and landfills that have been put in historically Black communities. You see environmental racism continue to be perpetuated in this regard. I don't think it's a coincidence that the community of Africville in Nova Scotia was raised to make way for growth in the city of Halifax. These are injustices that may have taken place in Canada's past, but their impact is still very much felt today. I think to myself about the education that I received growing up in Nova Scotia. I learned more in the education system about Rosa Parks than I did about Viola Desmond, despite the fact that I live 5 minutes away from the Roseland Theatre, where Viola Desmond took a stand against the racism that she faced, being told that she wasn't entitled to sit in the whites only section. It wasn't until I was well into my studies in law that I even came to understand the full details behind the story. Obviously, we've taken great strides to recognize the contributions that she and other leaders have made, not just honoring her as a National Historic Person, but putting her on our currency. But I think to myself about the other lessons that we haven't been teaching Canadian children to really drive home the importance of this. We learn more about Jackie Robinson's time in the United States, breaking barriers when it came to his baseball career, with very little information growing up through the education system about his time spent in Montreal. We learn great details about Harriet Tubman's work in the Underground Railroad, bringing people to become free to Canada, without a full appreciation of the time that she spent living in St. Catharines. If we actually inject a sense of justice earlier in people's lives through the education system, I believe that we can impact a culture change that's going to create a pipeline of professionals, both from the Black community and the broader Canadian community, who understand that the justice system has a role to play to cure some of these inequities. When I think about the work that the Black Justice Hub is going to do, it's going to provide an incredible tool, an online source of information and resources that's going to help legal professionals raise effective arguments about both discrimination against individuals and systemically against Black Canadians in this country. It's also going to support individuals from the Black community who are facing legal issues such as criminal child protection, immigration, challenges with incarceration, civil law. We want to be a good partner in this regard. We've been beginning to answer some of the growing calls to action to address overrepresentation of Black people in the criminal justice system, including recent changes that are being made through Bill C-16 around restorative justice and diversion programs. Funding for the Black Justice Hub is just one example. We are starting to see progress on the implementation of Canada's Black Justice Strategy, though I will be the first to acknowledge that we have more work to do. This strategy should be implemented over a 10-year period with a phased plan that responds to the more than 100 recommendations of the External Steering Group's report. As part of our commitment to make good on those recommendations, we announced just a few months ago an $8.6 million investment in Black-focused initiatives in 8 jurisdictions across Canada. Is going to include support for organizations that start developing Black-specific navigation services. It's going to support Black-specific programs to help youth in this country. There's going to be culturally appropriate and trauma-informed supports of services for Black victims and survivors of crime. This will include $400,000 in support of one of the projects, the Black Circle of Care, led by the Black Legal Action Center, to support victims and survivors of hate crimes and gun violence. There's more that we can do. There's more that we are doing. I'm seeing people break ground, including the African Nova Scotian Justice Institute in Nova Scotia and leadership in Ontario with the implementation of the impact of race and culture assessments, which again is being supported by a multi-million-dollar investment from the Government of Canada. We have an opportunity to correct some of the injustices that we see, but it's going to take continued advocacy. And don't assume that the Government of Canada, despite best intentions, is always going to be as informed as we should be. It can be very easy for political actors to gather in Ottawa to take advice from department officials on Parliament Hill, but there's no replacement for engagement with the people who know their community best. When you actually see the lessons that are being delivered to the government from the Black Legal Action Center, from other advocates from Black communities across Canada, you can learn much more effectively about how to solve the problems by listening to the people who are living through them. When we have the opportunity to engage, don't assume that we know what you're going to say ahead of time. There is a willingness to listen and to learn from the life experience of those who are working in the profession and serving Black Canadians, and we in earnest want to implement the lessons that we take. The work to shift the reality of anti-Black racism and systemic discrimination in the criminal justice system, it's high stakes. It's going to require deep systemic change with human and economic costs that will mount if we don't act. Today is a step towards that change. I want to say congratulations to the Black Legal Action Center once again for the launch of the Black Justice Hub. The work that you're doing is, though directly serving Black Canadians, is improving the quality of life that every Canadian gets to enjoy. I don't want to live in a community or a country where my neighbor is discriminated against because of the color of their skin, the community that they come from, or the culture that grounds their identity. We can build a stronger Canada by ensuring every Canadian has a place within it. I just think to myself that the greatest solutions to the challenges that Canada face rest in the minds of people often who are excluded from realizing their full potential. If we make sure that every Canadian has access to a good education, every Canadian has access to the basic services that Canadians depend upon and rely upon, and every Canadian has access to the justice system, we will be far better off as a country as a whole. I am grateful for the work that you are doing at the Black Legal Action Center. I'm grateful for the work of the hub that we're going to see rolled out. This is an incredible tool that's going to improve access to justice, and in doing so, build a stronger Canada. Merci tout le monde. You have a few thoughts on behalf of the Government of Canada, and I'm willing to commit to being a continued partner and pursuing racial equity in this country by supporting those who are closest to the work on the ground. Thank you so much. It's an honor to be with you.
Thank you, Minister Fraser, for your remarks and for the support of Justice Canada in making Black justice possible. So we appreciate the Government of Canada's commitment to initiatives that help improve access to justice and legal information for our Black communities across the country. So we'll now take our presentation from Tasik Hasmani and Melody Izadi. So these are both experienced criminal defense lawyers who have represented clients across a wide range of criminal matters and contribute to the development of the hub's criminal law resources. So they will share their perspectives on access to justice within the criminal legal system.
Thanks very much for the introduction, Sanjay, and it's really nice to see everybody here today turn out for this event. Melody and I have been working on this project pretty much since its inception. We were part of the initial advisory committee and then worked as well at the development of the materials. We had a group that did this with us on the criminal law related materials. And I want to acknowledge them because I'm not sure if all of them are here today. I don't see them in person. I'm not sure if they're online. But we had Dr. Kamisha Siblis, Professor Donardo Jones, and some of his students, including Gabby, Andre, and Jasmine. And we want to thank all of them for their work because it was really a collaborative project for us to get here. Just to take a step back and give you some background. So Melody and I are both criminal defense lawyers practicing here in Toronto and around the GTA. I was raised in Scarborough and did my work, my law school at Osgoode Hall University, which has an excellent criminal law program, but also has a number of other intensive programs. And I was fortunate to be part of the anti-discrimination intensive project, program, which started while I was at law school. And that program, allowed students to be, to have a secondment to the Human Rights Legal Support Center, which deals with human rights cases, but also had the great fortune of being trained and having academics teach me, such as Alan Young, Professor Bruce Ryder, a constitutional law scholar, who was really helped me in terms of the way I look at a lot of legal issues, particularly in the criminal justice system. And also at that time, Professor James Stavropoulos, who's now a judge as well, sitting in Brampton. But from that experience, doing my articles in criminal law, after I finished my articling period, I had my own practice for a number of years, and a lot of my early cases were focused in my community in Scarborough, representing marginalized people, racialized young men who got involved with the criminal justice system, mainly young Black men. And what we noticed, was always apparent but became very stark at that time, was the barriers to access to justice that many young Black men face in our communities and Black people in general. But for example, the idea of accessing a lawyer to have representation at this very tough time in someone's life when they are arrested and allegations are made of criminality, it's a very inaccessible system to get a lawyer to begin with. Legal aid exists. People think about legal aid, but the income thresholds are so low that most people who have non-transient employment will not be able to access legal aid. And so how do they raise funds to hire a lawyer? From there, the pressures continue, they mount, they snowball when people are arrested a lot of times racialized individuals will see that they are held for detention, even though bail is supposed to be the promise and the expectation. It's not for many Black persons who are charged with crimes, while they are considered innocent. That is our system. And they should be given that opportunity for bail. And even if they are given that opportunity, it doesn't always amount to it. And so these systemic pressures of being incarcerated at a time where you're really vulnerable and trying to get back out to your family, to your life, what it does is it puts a lot of pressure on individuals to take pleas and deals that are not really deals to get out of the system, or to get out of incarceration, but it keeps you in the system. You have a criminal record, your future is limited. At that point, you can't fault someone for taking whatever it is on the table to get out of jail, but that systemic pressure creates a barrier for them for the rest of their futures. The other thing that was touched on has been this, and it was raised in Antonio's speech presentation, was this idea of credibility and a credibility tax. And there's part of it which relates to what you were saying, Antonio, which is how do we present the information in a way that is accessible to the decision makers? But it also comes at the foreground when we have clients come to us who no one believes. The police have not believed. Their families may not believe them. They are left with very few people who do support them. A lot of times in my office, I have young racialized persons who come in and who tell me their story, and we go through the questions, and at the end they look at me and they ask me, do you believe me? Do you believe what I'm saying? And when I say that I do, and they look at me and they really question whether or not they can believe that. They say thank you. For what? Thank you for believing me. Something that should be just a matter of fact acceptance of what their story is, what they have gone through. They're not believed, and they're not believed a lot of times in the courtroom. When it's time to tell their story, everyone gets their day in court, but people experience that day differently. And a lot of times that credibility tax is put on them when they're on the stand. So it's our duty, like it was mentioned, to ask these questions, but also our legal system, we have to come to terms with the fact that there's a lack of understanding from the decision makers, from prosecutors, defense lawyers, we're all part of it, and judges. And that is where I think the hub will really be effective, and what we have tried to work on. And Melody and I have had a lot of experience in that. I'd like to turn it over to Melody to give you some background about her practice and how she became involved here.
Thank you. Good morning, everyone. So I am also a criminal defense lawyer. I do parole work as well. I've been doing this for over 11 years. And I've always been sort of laser focused that I wanted to get into criminal defense and to specifically litigate in the anti-racism sort of litigation world. My parents were born in Iran. I was born in Canada. And I've just been laser focused through undergrad, through law school, even in the types of cases that I take. And that's where I choose to litigate. And so a lot of my clients, similar to Tawfiq, are Black young people who are arrested and who are captured within our justice system. And there's a lot of complex issues, of course, that are in place. Everyone in this room knows that. I'm sure everyone in this room has had some lived experience with that. And part of what Tawfiq was talking about is this sort of safe platform to first allow your client to provide their story and to tell you what happened on arrest, but as well, what are the next steps? What do counsel do with that? What if someone, we don't have enough time to talk about access to justice issues here, but Tawfiq touched on it a little bit, but what about someone who can't afford a lawyer? What resources they have to litigate these very complex areas in the law? Or someone who is a lawyer who's embarking on this type of litigation for the first time. Not all the time are people situated, within a legal framework that has people that have litigated in this area. And you will find, if you do embark on this litigation, there's quite a lot of pushback and a lot of defensive from the officer that you're accusing or the Crown Attorney that you're pointing fingers at. And even putting the hint of racial bias out in the air, everyone gets their backs up against the wall. So it does take a sense of courage, I suppose, or sort of zealous advocacy to go down that road and to not be bothered by how socially that's being accepted and how to move forward. So with the point of the hub, we're trying to create resources for legal practitioners, self-represented accused, even people in the parole system who have access to the case law and to the templates that they can use, but as well judges, Crown attorneys who sometimes, and members of the media who sometimes characterize issues within the criminal law world of racial profiling as technicalities that get people off from charges, or technicalities that get you a lesser sentence. And we've all seen media reports that sort of are written in a way that suggests this person got a discount or a get out of jail free card. And to provide a background for some understanding as to why this is important and how awful this type of policing and the sort of opposition to allowing these types of arguments to be made is not helpful to anyone is really what we're trying to do here. And two areas, again, we can't touch on all the areas, but two sort of very important areas that we wanted to focus on are first, something called Morris reports or IRCAs, or enhanced pre-sentencing reports. So in the criminal law world, in that framework already, there are things called pre-sentence reports. A probation officer interviews an accused person and anyone else that they choose to have interviewed. So it could be family members, friends, co-workers, so on and so forth. And a report is created, it is sent to the judge, it is sent to defense counsel, it is sent to the Crown Attorney. An enhanced pre-sentence report, we call them Morris reports because it was sort of initiated by the case of R.V. Morris that went up to the Court of Appeal in Ontario. It does that, but from a culturally appropriate lens. And there's the Sentencing and Parole Project, who does very, very great work. They have specifically the interviewers are people with lived experience. They are racialized. They have academic experience in issues of systemic racism. And what they do is they create these reports for sentencing to allow the jurist and the Crown and the defense counsel to figure out how someone got from point A to point B. And litigating that and using those reports effectively in sentencing can be a little bit complex. I have seen counsel who get these reports done, but then ultimately end up making submissions to the court that sort of suggest that these individuals that are being interviewed are inherently criminal. So they're kind of perpetuating these racial stereotypes and myths. So for example, they're saying, well, Your Honor, this person lives in a bad neighborhood, they're racialized, so therefore they were destined for crime, which is, I can't even touch on how problematic that is. Rather, what we're trying to do is sort of unearth these very complex socioeconomic issues that are at play and to really provide context for how someone living in this society where there is systemic racism, that how they got from point A to point B, and to provide an appropriate sentencing plan for that person. So the case of R.V. Morris was really important in our sort of legal world. And it ultimately ended up allowing for judges now to take what's called judicial notice of racial profiling in the court system, which means defense counsel, we no longer need to prove that systemic racism exists. Judges can just simply accept that as a fact. And then the second thing I sort of wanted to touch on was just the idea of racial profiling. So when your client comes to you and speaks to you about the manner of arrest, whether there was excessive force used, etc., in terms of racial profiling, again, it's not a complex area to understand. Everyone in this room can sort of have the spidey sense and understand when it's happening. But to litigate it in court is a little bit more complex because no officer is going to get in the witness box and say, yes, absolutely. I stopped your client because he was wearing a hoodie and he's Black and he's young and he's driving a car. So our job is to sort of pick apart circumstantial pieces of evidence and figure out how we can move that forward in a way that's advantageous to the client. And so those are the types of case law and resources we wanted to provide, and also providing some educational basis as to how to bring that charter litigation. So for example, I had a case where a client is driving, he's Black, the passenger is Black, the person in the back seat is Black, they're simply driving, officer says they've been stopped for speeding. Let's just assume this speeding can be proven. That's not a contested fact. While the officer is checking the driver's license of the driver, once I looked at the police videos and the in-car cameras, the officer preemptively called for backup and asked 7 other police cruisers to attend while he was, from his vantage point, just, providing a speeding ticket. And then suddenly everyone's asked to exit the vehicle. There's a search of the vehicle and so on and so forth. You know how it goes. And so those types of cases, there has to be an issue spotting ability. And then 2, what do we do with that? Is it a charter application? Is it something for negotiation? Is it both? And so what we're trying to do with the hub and some of the information and case law and the resources we contributed was to help sort of navigate what you do with this information through the legal system.
Yeah, thanks, Melody. Just to pick up on some of those topics and cases. So this goes to the question that was raised earlier about case law and case law that's reported, unreported case law. So, the cases that Melody just mentioned, these are reported, so you will find them on the hub. The case of Morris is foundational at this stage when it comes to systemic racism and the impact in terms of how it may lead to a pathway to criminality or engagement in what intersects with the criminal justice system. And I really recommend to everyone, even if law is not your thing or reading legal decisions is not your thing, the appendix, what the judge in the Morris case did, and just to take a step back, before Morris, there was a push to have these impact of race and cultural assessments come to Ontario. They had existed in Nova Scotia for some time, where they had been unpacking all of this and dealing with it in the court system. And Faisal Mirza, who's a colleague of ours who we were working on in another committee before we took on this project, who's now a judge, had actually brought forward the case of Jackson. And Jackson acknowledged and laid the groundwork for this consideration of systemic racism in the justice system, which was then Morris. And in both of those cases, there were these impact of race and cultural assessment reports. And to read those, they are eye-opening. They are things that most people in this room will understand, but the way in which they are articulated, we're talking about an appendix from Professor Kwasi Bempu, Dr. Carl James, and Kamisha Siblis, who worked with us on this project. It was so important for the judge that, because judges in this system that do not have that capacity, do not have that competency without these kinds of resources. And so it was so important for the judge that they made that report an appendix to the decision. Beyond the corners of their reasoning, what their judgment was, they made sure that that was considered part of it. And it's online. Even when you go to Canley, you'll find that appendix. And I encourage everyone to read it, because what you see there is, this is only a few years ago, and we're breaking ground on this at this stage. And for us to look through the lens of this and make it accessible for the community, like Melody said, there are issue spotting considerations. What we've tried to do in providing these resources for access on the hub is to help individuals see that their issues, the issues that they are facing, are ones that have legal remedy, that may be breaches of their charter rights, so that they can take that forward. Because again, access is an issue. And I just want to, I know I have 1 minute, but just touching on a point that Tricia made about Section 15 claims and racial profiling and racial mistreatment. It exists obviously in the criminal justice sphere, where policing, oftentimes looks through that lens. And Justice Mirza's decision in a case called Murray, which will also be on the hub, we've moved away now. We're starting to move away from racial profiling to a concept of racial mistreatment. It's not just profiling, which may impact the initial part of the stop. It's how you are treated throughout the duration of that interaction. And in Murray, another case where you would see something similar to what Melody was discussing about one of her cases, the over-policing, the aggression of policing in a specific context that leads to serious violations of someone's charter rights, but also their human dignity, to be tasered multiple times in, private parts, and to be, held without their rights for a substantial amount of time. In these cases where we do see the courts find remedy, and, we do see how it's reported in the media as though they got off. These are charter rights. These are rights that every citizen in this country must have, and that we must zealously protect. And if we don't do that, we are not reaching our goal or the goal of the democracy or the Constitution and the Charter. And so it's really important for us to look at those kinds of considerations, and we must also acknowledge, the consequences in immigration. If somebody is charged and convicted, they can lose their status almost immediately. And same thing in the civil cases where we see things that go unnoticed for years, where people are in custody in really horrible conditions. We're talking not just double bunking in cells, triple, quadruple bunking, people not having access to yard or showers, really dehumanizing conditions. And I do want to say that, while there is still a lot of work to be done, it starts with what, this government has started to take a look at these things and provide funding to the centers, provide funding. The Black Justice Strategy is a very important initiative from the government. Justice Minister Fraser did acknowledge that the work, we're just starting it, and there's a lot left to be done. But it starts with resources like this. It starts with engagement in our community like this, and hopefully from there we can continue to make strides forward. Melody, I'll leave it to you to close.
Sure. So ultimately, we're hoping, just as Tofik was sort of saying, to empower and educate anyone that's litigating in the criminal law sphere as to how to navigate through these really complex issues, and to have those templates and forms to fill out and assist them, whether they be, like I said, a self-represented accused, a crown attorney even looking for some resources, or a defense lawyer embarking on this first sort of area of litigation, or people who are part of the justice system. Generally, there are a lot of social workers that are attached to some of these cases, especially for young persons. And so to be able to have these resources and a starting point to be able to sort of clearly allow you to find a pathway as to what to do when there is a racial profiling issue or a systemic racist issue in your case, that's ultimately sort of the goal. So empower and educate.
Thank you, Melody and Tafik. Recognizing potential anti-Black racism is often the first steps towards addressing it through the legal process. So as we move from discussing the development of the Black Justice Hub to exploring its broader significance, we are pleased to welcome Sasha Hart. So Sasha Hart is a human rights lawyer who has focused on advancing equality as well as addressing systemic discrimination and promoting access to justice. So today, she will offer reflections on human rights and help to frame the conversation that will follow as we explore the hub and discuss its role in supporting Black communities.
Hello, everybody. Thank you so much for that introduction, and thank you so much for the opportunity to participate in this launch today. I'm really, really honored to be able to join you virtually from Ottawa. And I just want to start by saying a major congratulation and kudos to BLAC for bringing what I think is a really visionary initiative to fruition. I have seen in my practice how badly, badly needed these resources are. I couldn't agree more with each of the speakers that have already shared from their own practices. I was just nodding my head in agreement to each and every one of them. So I really think that these resources, by making them more widely available to advocates and self-represented litigants, will really go towards advancing access to justice for Black people in Ontario and across Canada in a really concrete and tangible way. So just a little bit about me and my practice before I offer some remarks, and I'll try to be as brief as possible because I know we're approaching lunchtime. So in addition to other practice areas, my firm represents individuals in human rights and employment matters. And so a big part of my practice involves representing Black and other racialized individuals who've experienced discrimination in the employment context and at the hands of public service providers. A lot of my litigation work is before human rights tribunals. And based on my experience over the past several years, I just want to share what I see as three of the most significant barriers that Black people face when trying to access justice in human rights tribunals. But I do believe that these barriers are universally applicable to each of the other contexts that the other speakers have spoken about as well. So the civil lit context and the other contexts. And I want to touch on what I see as the three most significant barriers and how the Black Justice Hub, I think, really will help address each of them. So, the first barrier that I've observed in terms of the challenges that Black litigants face is the failure by advocates and decision makers to consider the broader social context related to their claim. So many well-intentioned advocates sometimes forget to highlight the broader social context in their submissions, or they simply don't always see the importance of doing so. And by social context, what I mean are things like statistical data about the manifestations and prevalence of anti-Black racism across various social areas. So when we as advocates present submissions to courts or tribunals that don't really frame that social context, that don't include that social context evidence, I think it then leads to decisions that are made in a vacuum and that are, devoid of context often. And it leads to and I think the major risk is that it leads to decisions and analyses that are more likely to be colored by what I like to call the myth of Canadian racial exceptionalism. So the myth that somehow we are exceptional on this side of the border when it comes to racism, and that it's generally less prevalent here or non-existent. That is a major myth in Canadian society, and it operates and influences consciously and subconsciously our psyche, including the psyche of decision makers and advocates. So I think it's just really crucial for decision makers to take judicial notice of the broader social context realities of anti-Black racism and to ground the individual claimants and to ground their decision about the individual claimants' experiences in that broader social context reality. And as advocates representing Black clients, we need to be pushing decision makers to take judicial notice of these social context realities. So I think that the Black Justice Hub materials will help to address this problem by making that social context evident, that social context data and information readily available for advocates and litigants to be able to weave into their submissions. The second barrier that I see Black litigants often facing is this inadvertent heightening of the evidentiary standard that they need to meet. Here I'm talking more so in human rights and civil claims. So in the human rights case law, you'll often see the refrain that it's repeatedly stated that allegations of race-based discrimination are notoriously difficult to prove. So decision makers often say this, you'll see it in the case law. And the case law mentions that, this is because racism tends to manifest itself more often in very subtle ways, including unconscious ways. And while this is certainly true, I would also say that it also tends to be difficult to prove racial discrimination because there is an overly high evidentiary threshold that tends to be applied both by opposing parties and by adjudicators. So in the human rights law context, the case law is very clear that we do not need direct evidence of discrimination in order to meet the balance of probability standard. It's very clear that circumstantial evidence suffices and that an inference can be drawn from that circumstantial evidence. The case law is also very clear that race need not be the sole or the major factor leading to discriminatory action or decision, but that it need only be one of the many factors at play. And yet, I often see respondents and adjudicators, and even sometimes very well-meaning advocates representing Black individuals downplay the significance and role of circumstantial evidence and of direct and of indirect evidence. And then I think this then results in the legal test that is to be met being set inadvertently higher than what the case law actually requires. And so I think here is where I see the Black Justice Hub materials also helping to address this specific problem, in that by providing accessible, comprehensive, ready-to-use submissions that properly set out the correct legal framework and the correct evidentiary standards, and that, remind us of, the role of circumstantial evidence, the role of inference, and all of those important key concepts. I think just by having that readily accessible, it's really going to strengthen a lot of our submissions. And then the last and final barrier that I often see Black litigants face is, unfortunately, the failure to have the full range of their intersecting identities taken into account. So there's often, in my experience, an inadequate consideration of intersectionality by decision makers, and again, sometimes by well-meaning advocates as well. So we know that Black people are not a monolith. We have unique experience based on our intersectional identities. So what I mean by that, based on our gender, our disabilities, our gender identities, our sexual orientation. And in a recent decision of the Supreme Court of Canada, the Kanyinda decision, the court emphasizes the importance of taking a intersectional approach when it comes to Section 15 discrimination claims. But I do believe that same analysis, the intersectional analysis, is also important in human rights claims as well, outside of the Section 15 context, so in human rights tribunal forums. And the majority of the court in Kanyinda, it's a beautiful decision. I really encourage you all to read it, and for us all to think about ways to incorporate what they say about intersectionality in all of our areas of law here today. But the majority decision reminds us that the failure to account for intersecting identities can obscure the specific adverse effects that are experienced by a claimant, and that it's really only by taking an intersectional approach that we can truly shed light on the full extent of the discriminatory effects of a given policy or law or action. And so when we don't take an intersectional approach to anti-Black racism claims, I think we risk the discrimination at play not being fully recognized. And essentially we risk there being a greater likelihood that the claim is dismissed. So I think it's really important for us to remember to take an intersectional approach. And I think that's another thing that the Black Hub materials will help advocates and litigants to be able to do in their submissions by providing information that not only talks about, that not only provides social context about the realities of anti-Black racism, but also how other identities intersect with race to produce unique and compounded forms of discrimination. Just to wrap up, I think that, as I've said, the BLAC Hub materials are going to help to ensure that anti-Black racism cases are litigated in a manner that, one, is grounded in social context, two, that applies the correct evidentiary standards and legal frameworks, and three, that takes a critical intersectional approach. And I think in doing so, this resource has the potential to significantly promote access to justice within the Black community. And for that, I am super excited about its potential. And I just want to thank every single person that had their hands on this initiative. And again, to BLAC for spearheading this important initiative.
I know we have a few discussions happening in the chat. And of course, if there's any question, if we have any questions in the room, just raise your hand and we'll take a mic to you. All right. So I did see one online that I want to jump in. And some of them, I promise you want to get us in trouble, so I'm not going to answer it. One of the questions online says, how does Legal Aid contribute to system racism, or does it not? I'll assume the question means, because we're a clinic funded by Legal Aid, I'll assume that the question means, what is Legal Aid doing to contribute towards combating anti-Black racism? And I say funded BLAC Legal Action Center. Maybe that's a politically correct answer that I have to give being here today. But seriously, we are a clinic that's funded for that reason, recognizing that there's a gap in representation. Certainly resources are never enough. And said we argue all the time that we are underfunded, but to the extent that, we are funded to achieve a particular mandate in doing the work that we're doing. One of the benefits we have, though, is that as a clinic and a specialty clinic, we're uniquely placed where we get core funding from Legal Aid Ontario, but a lot of the work that we do beyond just providing services to persons who are unable to afford a lawyer is that we do get public support. We do get ordinary community members that contribute to us, to allow us to do work beyond the day-to-day legal services. And we do have partnerships like this with the federal government that allows us to take on things that are not providing services to the community directly. So this sort of funding from the federal government allow us to do work that probably would not ordinarily fall in the work that we do day to day through Legal Aid, and that's funded by Legal Aid. And so it's important for us to maintain these partnerships with other organizations, with other charitable organizations and other non-for-profit organizations that provide funding for us to do this kind of work. Because if it might be that taking on and hosting a hub, putting resources together may not be considered legal services within the LASA definitions per se, but because we can depend on you and the contributions coming from you and other members of the community interested in the work that we do, we are able to provide this kind of support and lead or provide that sort of basis or somewhere you can go to share the information and get the information as a community legal clinic. So that's how I answer that one. Who to contact regarding Black Justice Hub? It's the Black Legal Action Center or email address. And I thought we had that somewhere, but it's info@blac.clcj.ca. So that's our general email address. Yes, it's posted in the chat of how to contact us if it is that you would like to make contribution, add additional things to the Black Justice Hub. All right. And you say that Deborah has her hand up. So Deborah, you can go ahead.
So I'll be very brief. Thank you so much for the information. Can you I know you did speak a little bit to IRCA. Can you just generally summarize what is your role in whether it's the administration or delivering or supporting IRCAs?
Of course, certainly. So impact of race and culture assessment, that is not a legal aid funded resource. So these are resources or programs that we do take on in support of our community. That a main example, this is funded by our community support. So
contribution we see from the community to do that. An impact of race and culture assessment, and Melody and Tawfiq spoke of. It's what we do is when we do receive those requests, we do have IRCA writers that we have specifically brought on board to help us to create these reports. So these are reports that look on the social circumstance of a Black person. And certainly to get an IRCA, you have to be Black. That's what it focuses on. And so it takes a look on the circumstances of that person who is now being convicted, because that's usually where the IRCA comes in. You've been convicted and now you're looking to sentencing, and the judge, or you want the judge to take into account how your circumstances as a Black person contributed to you being where you are coming in conflict with the criminal justice system. And so at BLAC, we do receive those requests. We do have IRCA writers that we have specifically contracted. One of the difficulties with IRCA right now is that they're taking a ridiculous amount of time. There are not enough writers. And so judges may opt to move ahead without those reports, which certainly works against the accused. What we have done is, because of the writers that we brought on board in-house, we sort of try to expedite that timeline. So you may be looking at ordinarily going through the system 6 months, 9 months, a lot of time. I'm not going to give you a commitment here at BLAC, but I will say that ordinarily going through our system, the timelines that we have set for us internally is that we shouldn't have an IRCA that's going beyond 3 months if it is that we are able to walk that, get the contribution of counsel and all those persons. I will say we're a little bit more aggressive with our timeline, and I believe we've been able to keep our timeline to about 15 weeks of going through IRCA right now, the IRCAs that we have received once we do have counsel's participation, able to access the client and do those, which is certainly way shorter than what exists right now through other means. So I'm quite proud of that.
Is the BLAC Justice Hub also for paralegals or aligned professionals like social workers?
So the BLAC Justice Hub is for everybody who does the work that we do. So it's ordinarily developed for professionals, certainly, but we do recognize a lot of our members of our community going through the system on their own. I should tell you here at BLAC, we are assisting persons that have been going through the system for 10 years, and they will tell me things that I don't know, and I'm a lawyer, self-representing themselves and going through. And so they have a lot of experience and knowledge about how the system works. But they may get to that point where they do need a little bit of help, and that's where we get in. It's ordinarily designed for professionals to be able to use these materials in advancing the cause, but self-rep persons will certainly find benefit in using them. And where are mics? Oh, perfect. Go ahead.
Hi there. My name is Renata Austin. I'm a lawyer with the Office of the Children's Lawyer. My colleague Ken Atkinson is here as well. So the Office of the Children's Lawyer, we actually represent children across Ontario in all child welfare proceedings, as well as in parenting matters. Prior to that, I also ran a community practice where I primarily represented Black women in the child welfare system. So I did want to stay to take the opportunity to talk about child welfare because I was a little bit disappointed that I didn't see more of an emphasis on child welfare, because I would submit that the child welfare system is actually the system that has the most contact with Black people, certainly in Ontario, based on my experience in practice. So I took a quick look at the website, and it looks like the materials haven't sort of been developed yet, which is disappointing, but I think there's also an opportunity, and I'm speaking for myself here. I'm not speaking on behalf of Meg or the government of Ontario. In my experience, and I think in developing these materials, and I'm hoping this commentary will be sort of taken with the way that it's intended. In my experience, I think one of the challenges with child welfare advocacy in particular, and how anti-Black racism advocacy often plays out, one of the things that needs to be kept in mind and understood, and where I've seen sort of mistakes being made in the past, is a lack of understanding of the actual legal framework that within which child welfare operates within. So unlike other areas of law where the law is concerned with sort of a specific point in time with incidents that occurred, so in the criminal context, a crime occurred, what happened in that point in time, or human rights. discrimination occurred. In family law, it's actually quite different. Family law is concerned with prospective facts. It's not about what happened, especially in child welfare at the time of the intervention. That's actually the start of the case. By the time the case actually ends, the person who's making a decision about what's in a child's best interest, they actually have to look at the facts at that specific time. And I think one of the challenges and mistakes, if I could be so bold, that I've seen is people who do anti-Black racism advocacy work in other contexts, trying to take that and slap it onto family law. It doesn't work. Child protection is one of the few areas where you can be completely vindicated. CAS could have gotten involved in your life because they were discriminatory, they were wrong, and you can still lose your child in the process for two reasons. One, we deal with prospective facts. So it's not about they could have been wrong at the time it happened, but 4 years later, your child may have moved on. They might have attached to different caregivers, their circumstances might have changed. And one of the challenges and mistakes that I see in the advocacy that's done in the community is a lack of appreciation for that. I see a lot of people coming in and being very focused on the wrong that happened and not what the court actually has to look at, which is what are this child's circumstances now and how do those best interest factors apply? So there are definitely opportunities for advancing sort of anti-Black racism issues, but it has to be very specific in terms of understanding the logic of the child welfare system, which is, again, we're dealing with prospective facts and there are time limits that matter. So that advocacy, the evidence, how it goes in, what the opportunities are, look very different than they look in every area of law. And I think it's really important in developing materials, because one of the things I saw is that you're hoping to develop a plain language guide for litigants to be able to understand how to navigate the system. What I see constantly is not only the litigants, but often the advocates themselves do not understand the logic of the framework and that the remedies look different in child protection. If your goal is to keep families together and keep your child at home, the advocacy tools that you use in the criminal justice system in the human rights context are not going to work in child protection. So I'm disappointed that there aren't materials there, but I hope in terms of developing it, that is taken into consideration, because too often I see these discussions around child welfare that people feel good. We can all sort of slam the CAS, but it doesn't actually do the thing that I think we're all seeking to do, which is to keep Black families together and to keep children at home. So I hope that is incorporated into your materials so that both the litigants themselves, as well as the people who are doing advocacy on their behalf, have that fulsome information and are able to actually achieve the outcomes that we're seeking. Thanks.
Well, you appear at the Black Justice Hub from the Office of the Children Lawyer. You're very bold to come in here, so I do respect that. I will flag.
Speak for myself.
Very well. I don't mind. Once you have the experience, it's okay. All right. I'll say this: we do have some materials in child protection and child welfare that's putting up. But I'll say this: I'm going to take you up on your offer. Or even if it wasn't an offer, I'm assuming it is. So I'm going to take you up on it. And I flag for you because I'm going to slam the CAS here. And I know you say we don't, we shouldn't. We do work with the CAS. One of the difficulties we had here working with these materials certainly is we do have material that's developed from the perspective of the lawyer who's now representing the client. And one of the things that we wanted are materials that look at it from the other perspective, which is the CAS's perspective looking on. We were only able to get one person from CAS after the number of different CASs that we're sort of trying to collaborate to see what those materials look like, who are willing to contribute to that material, particularly for the fact that they work on the other side. And certainly while we ordinarily at BLAC would say that we may ordinarily be on the other side of CAS, where we provide support. We generally don't provide services in those areas, but we provide support to other community organization and partnership, where they're the one providing navigational services. We may help them with the research and that sort of stuff behind the scene. It was difficult to get CAS to work with us and combining those materials from their perspective, which is what we want. I think it would be very useful to have those. And I'm really happy you're here. So I'm going to take you up on it.
If I may just clarify, we're with the Office of the Children's Lawyer. We actually represent the kids.
Yes.
We are separate from CAS. We're often involved in litigation and on the other side from CAS. We don't represent parents. We don't represent CAS. We represent the actual young people that the courts are making decisions.
Yes, certainly. Thanks for that. Yes, I do recognize you had pointed that out, but I was just flagging that. So that's where we slammed the CAS, that even getting this. I will admit we didn't reach out to the OCL, and maybe I'm happy to know that we can reach out to the OCL now, but we'll talk. We'll talk. All right. And do we have any others? So I know we are just slightly over, but I will say, I'm sure I didn't miss any in the. I know Venus is monitoring the chat, so if there's any other, Venus, let me know. Atrisha. Okay, so Atrisha is at Lewis Litigation. Look her up online. Lewis Litigation. I know because I do work with Atrisha, quite a bit of work with Atrisha. So Lewis Litigation, you can find Atrisha there. And then I did see this question to clarify, did you do the psych evaluation? I did. Oh, okay. All right, no problem. All right, so I think we're at the end. So I'll say this, we are still uploading the materials. We do have another set that we will now make live there, and we're still doing some tweaking on the website, so allow us some time to do that, but you know that it is out there, and I do expect to see contribution coming in from our different partners and what they think is useful for us to have there, and so that we can build out. So again, you spent your morning with us, and 2 hours on a Thursday this early, we're eternally grateful. And we know that you're here because you're dedicated towards the work that we do and towards advancing the causes that are important to our community. So thanks again for being here. And we will launch from here and continue the work that we're doing. All right.